appeals in the matter of Pfizer and Flynn Pharma and the CMA.
May it please the Court. I appear with Mr. Holmes, King's Counsel, Mr. McLeod and Ms. Breckenridge for the CMA, my learned friends, Mr. Brealey, King's Counsel, Mr. Donoghue, King's Counsel, and Mr. Johnson, here for the Pfizer Appellants, my learned friends, Ms. Stratford, King's Counsel, Mr. Pascoe and Mr. Richardson appear for the Flynn Appellants. The proposal from the CMA side is that we will address you on our application for permission to appeal. I will go first, dealing with our proposed ground 1 on the excessive limb. My learned friend, Mr. Holmes, will address you on the unfair limb, so proposed ground 2. Ms. McLeod will address you on the absence of confirmation bias, that is our ground 3. And we will then address the appellant's substantive, procedural and penalty grounds after they've opened their appeals tomorrow.
Just so far as permission to appeal, we just want you to get on with your arguments. We will decide permission to appeal and everything else as a matter of formality in the judgment.
I'm very grateful. I will do it on that basis. I'm going to structure my submissions in 4 parts. First, start with the relevant legal principles on the excessive limb. Secondly, I'd like to show you the essential elements of the CMA's decision on the excessive limb and how it applied those legal principles. Third, I'll deal with the CMA's ground of appeal on excessive and respond to Flynn's main arguments in response. And fourth, time permitting, I'll address the main point that Flynn makes about its comparators. We can start then with the law, if I may, and I'd like to start with 4 key authorities. The first is this Court's judgment in these proceedings. The other 3 are the liotharinine case, the European Aspin case, and the proceedings for the cat in Le Paterel. So we can turn up, please, this Court's judgment in these proceedings 6 years ago, and that's to be found in the core bundle at Volume 2, tab 31, at page 594. And I know this will be a familiar passage to at least one member of this Court, but just to sort of show you what was said in the key summary distilling the case law in paragraph 97. We can pick it up at Roman numeral.
I suspect you can take this all reasonably quickly.
I'm going to.
We did have it in Sinvard, didn't we?
We did, my lord. I'm going to show you that as well. It's just simply.
And you've got the same court.
Yes, indeed. And delighted to see everyone again on this occasion.
You may be.
The one thing you are going to have to do, though, I'm afraid, certainly for me, working electronically, is that the electronic page numbers bear no resemblance to the printed page numbers whatever. They're not even close.
That is the first rule of bundles, that the digital bundles are always numbered differently to the paper bundles.
But normally it's only by 1 or 2 because somebody's made some
Yes.
sort of little glitch, but this is way out. 594 printed is 669 electronic on my, unless I've just got a unique electronic bundle.
Yes, my lord. I will do my best with the electronic bundles. I've been working off the hard copy bundles, and therefore there is a mismatch.
I mean,
I apologise.
Well, Justice Zacaroli will. It's the same. Okay, right. So if people can bear that in mind.
So, in relation to what is said here in paragraph 97, Roman numeral 5, simply just to note that the cost plus test, comparing the cost reduction with the selling price, discloses the profit margin, one then asks whether the margin is excessive. The important point for today's purposes is what is then said. You compare the price against a benchmark, and it identifies 2 examples, one being return on sales, or another appropriate benchmark being return on capital employed. And the Chancellor, as he then was, also described the excessive limb in paragraph 252. Yes. Which is, I'm told, is at page 708. It's at letter B. And you can just see, again, a very clear statement as to what the excessive limb requires, comparing cost reduction actually incurred in relation to the product, including a reasonable rate of return, and that is what the test implies. And that the CMA directed itself to both of those paragraphs in the decision at paragraph 4.10. The next what I would like to do is to show the court two crisp statements of principle relating to the appropriate role of cost plus in a case that will be familiar to you all in liotharamine. Could we start, please, by picking it up in the tribunal's judgment, and that is to be found in the authorities bundle at tab 52.
Just checking, we were asked, I think, all right, it came to me late yesterday, an application for permission to use a transcript. Is there going to be a transcript?
My Lord, I understood, yes, that there is. The parties agreed that Opus, and we had understood that the court had given permission.
Yes, we have. Yes, so it is being recorded, just in terms of our notes and so on.
Yes, that is my understanding, my Lord.
I mean, it's just normally there's microphones and things like that.
Text moved on.
We have apparently had confirmation that
Yes.
they are transcribing,
Okay.
so they're obviously getting cleverer and cleverer. I
Good.
don't know how it's being done.
Thank you.
So the first is in the tribunal's decision, and it's just one passage which is to be found in my version of the electronic bundle at page 811. And it's paragraph 348.
Paper?
Well, and I believe it's the same. My numbering is the same, 811.
Well, no, 811 electronic is page 737. 736 printed. Sorry, are we still in the core? No. Where are you?
I'm in the authorities bundle, my Lord,
Authorities,
at tab
okay.
52.
Sorry,
And
hang on. That may be a better bundle. Give me a second.
Well, it's only 25
Okay.
Which is the paragraph?
paragraph 348, my Lord,
Authorities.
of the authorities bundle. And the short point is that it was argued in that case that the CMA's cost plus approach had been fundamentally inappropriate to the pharmaceutical generics industry. And then the tribunal responds, in my submission quite correctly, that cost plus is an appropriate benchmark for determining a competitive price in generic markets, characterised as they are in that case, and indeed in this case, by low levels of innovation, and that therefore they agree there was no policy considerations that absolved Advance from its special responsibility as a dominant undertaking. And there is then a further statement of principle, which will be familiar to this court, but if I may just briefly to remind you. So in the authorities bundle, tab 57, the relevant paragraph is paragraph 199. And of the hard copy, I have that as 991, page 991. And electronically, I have that at page 1016. I just asked the court to remind itself of what it said in that paragraph. And my submission will be that this is precisely what the CMA did in this case, that it relied on a cost-plus calculation, but then, of course, it also cross-checked that calculation against various other pieces of evidence that were put before it. And we'll come on to that in a moment. Before we do, could I just turn from cost-plus generally to focus on the plus, the reasonable rate of return, and to see what a couple of authorities say about that issue, because that's really central to our first ground. And could we start, please, by looking at what the European Commission said in its Aspen decision, and that's to be found in the authorities bundle at tab 78. And the relevant passage that I would like to focus on is in recital 127. And that's to be found in the electronic bundle at page 1612. And of the hard copy at page 1587. You can see under the heading Profitability of Comparator Companies, when assessing the excessiveness of the product's profit levels, the Commission's preliminary assessment accounts for the fact that undertakings need to earn a reasonable profit margin, and in particular, a rate of return of capital employed, ROCE. Indeed, in markets working under conditions of normal and sufficiently effective competition, so you can see from the footnote that's a reference back to the seminal judgment in United Brands, undertakings are active in the market because they expect to earn a financial return sufficient to compensate their investment. And of course, the Commission goes on to say in the next recital, different circumstances of different cases mean that different methods may be suitable. But can I show the Court what the Commission goes on to say, importantly, about the plus in recital 154, which is on page 1593 of the hard copy, 1618 of the electronic copy. And this is under the Commission's preliminary conclusions. It says the Commission recognises that companies are entitled to make a reasonable rate of return in order to cover their cost of capital. These two things are indissolubly linked to one another. And you can see in the last two sentences that the plus element allows recovering the costs of capital, and that in principle, no further recognition of the remuneration of capital employed in the products is therefore required. And I should, while we're in the decision, briefly address the Court on why the Commission didn't, in this case, adopt a ROCE approach. And you can see that in the next recital, that it did consider calculating the capital employed and the associated cost of capital, but on the particular facts of that case, Aspen didn't have any accounting of tangible or intangible assets that it acquired in relation to these anti-cancer medicines, which basically meant in that case the ROCE approach was too complex and not practicable. And as I will seek to show you, that is very different from this case, where it was practicable and indeed a valuable part of the CMA's analysis. I just have one final authority to show the Court, and that is the Tribunal and this Court's judgments in the recent collective claim for damages relating to BT and having excessively priced to various residential customers. And that's the Le Patorel and BT. And that is to be found, first of all, the Tribunal's judgment in tab 55 of the authorities bundle. And the relevant passage, which I have asked the Court to read to itself, is paragraph 566. And that is to be found on page 933 of the electronic version, and I believe page 908 of the hard copy. It appears under the heading Law on Reasonable Margin.
It's described there as, in economic terms, a cost, but it's not part of your cost in the cost plus
Yes, this is a point of a little bit of confusion for the tribunal, my lord. In essence, the plus is both a cost to the business and a return to the investor. And it's a point that's addressed in footnote 90 of the judgment, which I will come and show you.
But the return, the reasonable rate of return would apply whether or not the business had capitalised itself in a way which incurred cost.
Well, the reasonable rate of return is there as a return to essentially pay the investors for the risks that they incur in the money that they have either lent or invested in the business.
But on a basis that's not specific to that business, but is on a more general level, isn't it?
Yes.
What a rate of return would be expected in that market.
Yes, we're going to come on to look at exactly, my lord. We look at the weighted average cost of capital, which is a typical measure of the reasonable rate of return. And I'm going to address you as to how that was calculated, and moreover, how that was specifically related to the phenytoin capsules at issue in this case. But before I get there, if I may just show you one final authority, and that is this court's judgment in Le Paterel refusing permission to appeal last year, and that is to be found in the authorities at tab 59. It's just one passage, hard copy page 1019, and electronic 1044. And as you can see, this was a case of an allegation that was ultimately dismissed by the tribunal that BT had charged excessive prices for various of its residential telecom services. The relevant bit for our purposes is about 5 lines down.
Sorry, paragraph.
Paragraph 3, my lord. And we can pick it up 6 lines down. One central method is known as cost plus. Under this, the cost, together with an appropriate return on capital employed, so we see again a reference to capital employed, the plus, providing the goods or service in question is established. The resultant cost plus figure is then compared against the selling price to determine a differential. The selling price might be established on an annualised basis or as an average price, as it was here, over a fixed period, such as the period of the alleged infringement. And that's referred to as the limb 1 or the excessive limb test. Now, if I may, having looked at those various authorities, apart from the common thread that Justice Green was in all of them except Aspen, I'd like to draw 4 threads, if I may, on what they say about the reasonable rate of return. 4 propositions. The first is, undertakings are entitled to cover their cost of capital as well as their cost of production. The second is, cost of capital for this purpose is defined as the profit that enables investors to be sufficiently remunerated for the investments they make in the business. The third proposition is that the rate of return reflects the minimum sustainable, perhaps a better word, normal return that investors would expect to earn in the relevant business in order that it makes it worthwhile for them to commit funds to that particular line of activity and that company. And the fourth and final proposition is... I apologise, my lord.
Just a moment. Yep.
And the fourth and final proposition is the law doesn't prescribe one single approach to determining a reasonable margin. We saw that in both Aspen and the Katz decision in Le Paterel. But what I would add is that comparing the return on capital employed with the weighted average cost of capital is a well-established and widely accepted way of assessing excessiveness. Indeed, we saw that in Le Paterel, and although I won't take you to it, I'll just simply note the tribunal late last year, in another excessive pricing case, Rachel Kent and Apple, also made the same point. I'll give you the reference for that. It's authorities, tab 60, page 1077 of the hard copy. The relevant paragraph is paragraph 561, subparagraph 3. And my lords, what I intend to do now is to move on to show you in some detail, and I'll take it as quickly or slowly as suits the court, the key elements of the CMA's decision. And the reason why I say this is so important is to show you what the CMA did and why it did it. And because I will be submitting that there are material misunderstandings, indeed mischaracterizations on the part of the tribunal about the CMA's analysis in its decision. And what I want to do is try and walk you through the CMA's application of the excessive limb in 5 steps. Now, first of all, just to find the decision, it is in the core bundle, and it's in volume 4, and in tab 33, and the relevant starting page, at least on my notes, is page 1146, which is 1221 of the electronic bundle. And I'd like to start with the first step, please, which is at paragraph 5.203.
Sorry,
5.203, my lord. This is just to walk you through the analysis that the CMA carried out.
I'm not going to hurry you up, but we've all read it in some detail, but I'm not going to hurry you up. We recognise that one of the unusual features of this case is that your central criticism is that the CAT didn't properly read the decision, and therefore an analysis of what the decision actually says is really important.
I'm grateful, my lord. In which case, I'll just simply explain that the first step was obviously to identify the relevant prices, and then for your note, they're set out in table 5.8 on page 1147. The second step, which begins on the same page, is to ascertain the costs. You can see that analysis in 5.207. And the only point I want to stress at this stage is that you'll see in 5.207.1 that the CMA used the actual cost of goods that Flynn paid for Pfizer's capsules. This is a really important point for the first part of our ground of appeal, where the tribunal thought we were disregarding an inconvenient truth.
No.
And you can see again the
Sorry,
table.
that's paragraph 5 point.
That's 207.1, my lord.
Yes.
There is then, and I won't take you through it, but just simply to note, there is then a discussion, of course, by the CMA about attributing an appropriate portion of common costs or indirect costs to the capsules, and that is set out over page, paragraph 5.211 onwards. I'm not going to dwell on that now, but I would like, if I may, very briefly, to pick it up with the third step, which was the approach that the CMA thought to be appropriate in calculating the reasonable rate of return for Flynn. And I'm going to focus on Flynn for this morning's purposes. And you'll see, actually, on page 1150, in paragraph 5.217, that the CMA explains that it's going to take a rocky approach, and then it goes on to explain why it doesn't consider that it wants to have its primary case based on a return on sales approach. And that's for 2 essential reasons. The first is that a return on sales has no normative value. It needs to be compared, and it doesn't assess the returns linked in any way to the risks and the activities engaged in by the business. So it's not a risk-return framework. That's the point in paragraph 5.217.1. And the second is, the next subparagraph, that the return on sales approach is really problematic when you consider the fact that Flynn was paying such high supply prices to Pfizer. The point there being is that the higher the supply price paid to Pfizer, the lower the percentage margins on a ROS basis will appear. And we don't say that disqualifies return on sales, but we do say it goes to the weight to be placed on it. And in fact, the CMA does a cross-check using return on sales, as I will show you, but nonetheless, it is a very important point to keep in mind, so that one is not beguiled by low percentage margins. The next point, if I may, is just to show the court the essential elements of the analysis done as part of the ROCI approach. And we can pick that up, please, at paragraph 5.223 under the heading Capital Employed, which is page 1151 of the hard copy. And 1226 of the electronic copy. And what you can see as we walk through these paragraphs is that the CMA is squarely focused on what Flynn was doing in terms of being marketing authorization holder for Phenytoin capsules, and that Flynn fairly had accepted it didn't have much fixed capital employed. But then over the page, what one sees at paragraph 5.226 is you'll see that Flynn is setting out, and the CMA agrees with it in this respect, at least in relation to the first respect, that the capital employed consisted of the cost of its working capital, and then the CMA also analysed Flynn's claims in relation to strengthening the supply chain. What you will notice, conspicuous by its absence, is at no point did Flynn, either during the investigation or during the appeal, ever suggest that its product unit costs were in any way capital for this purpose. That I will come back to. And what the CMA then does is just to simply pick it up through the headings of its analysis. If you go over the page to page 1153, paragraph 5.231, you'll see the CMA then analyses carefully each of the inputs. It's page 1228 of the electronic bundle. And the first is the working capital. So in other words, that is looking at Flynn's actual purchases and sales data and looking at its debtors and creditors based on Flynn's terms with its trading partners. And you can see in 5.233 that the CMA agreed with Flynn that it's legitimate for it to have a return on that capital, not only in terms of the stock that it had built up, so that it had to deal with any disruptions in supply, but also in terms of having cash on hand in case it takes time for Pfizer to be paid and for the NHS to pay Flynn. And the upshot of that analysis is that the CMA calculated that Flynn's working capital was $3.5 million for each year during the 4-year relevant period. And you can see that conclusion at 5.235. I should say, as you can see in the next paragraph, the CMA does then go on to analyse, as a sensitivity, if Flynn were right to say that the value of its stock was more than that, £5 million, it then carried out a cross-check on that analysis, which is to be found at paragraph 5.400, but it didn't affect the excesses found. Now, I'm not then going to laboriously go through each of the other assets, but you can see that what the CMA does is it analyses each claim made relating to every alleged capital employed, and what it then does, having gone through each of those assets, is it turns to what the reasonable rate of return should be. And you can find that, please, at paragraph 5.259 on page 1158 of the hard copy. Page 1233 of the electronic copy. And what you can see is that the CMA's analysis is multi-layered. So what it does is it starts out by saying it will look at various points of evidence that can inform the appropriate weighted average cost of capital. And there are two set out in 5.260. There is Pfizer's WACC, which is said to be around 9%, and then Flynn's own industry expert has put forward average cost of capital figures in this industry between 7.7 and 8.2%. I should just note, and I will come back to it, I promise, but just to tell you that when Pfizer told the CMA its WACC was 9%, it also said that the WACC of its manufacturing facility for the manufacture of capsules was not materially different from that 9%. And the reason I stress that is because that's one way in which the WACC that the CMA applied to Flynn was appropriately calibrated to the supply of phenytoin capsules. Not the only way, but one way, and I will promise to come back to that in my submissions. What you then see is that the CMA addresses various concerns and disputes raised by Flynn as to the use of its weighted average cost of capital. And some of the points being made are ones which are now renewed in its respondent's notice. And if I may, I'd like to pick up just a couple of these so that the court can see what the CMA said about them in the course of its analysis. The first point to note is that the CMA was addressing an argument based upon, you'll see this in paragraph 5.263, that the weighted average cost of capital is the minimum return that investors would require on invested capital, and therefore cannot be used as a benchmark. Well, this point is, as you will have seen, directly in conflict with what the tribunal said in Le Paterel, what the European Commission said in Aspen, but the CMA addresses it head-on a little earlier in its decision. If I could just briefly show you that, you can just see the analysis. So paragraph 5.88 on page 1122. And this is where this point about a minimum or floor price is being addressed.
So I missed the number. Paragraph
5.88, my lord, which is page 1197 of the electronic bundle. And what you can see explained there, as indeed the authorities show, the cost of capital reflects actual returns earned on average across a range of markets. It's observed returns. Some markets will be more, some markets will be less competitive. None of this is idealised or theoretical. It is grounded in the real world based on market returns. But the other point, which I think is some significance, is made in the next paragraph, paragraph 5.89. And this appears to have escaped the tribunal's attention, which is that the CMA does not consider that any profits over and above the cost of capital are automatically excessive. Indeed, on the contrary, it recognises, of course, that market conditions change, and at different points in time, there may be returns observed by an undertaking that are above what is the weighted average cost of capital. And if one casts an eye down to footnote 780, you'll see the CMA specifically gives examples of reasons why that might be. For example, where you have had a highly successful marketing initiative leading to a drive in demand for your product and higher profits, or perhaps that you just have superior productive efficiency. And it really is important for me to stress that at no point was the analysis as simple and crude as the tribunal made it out to be, that the CMA took a per se approach that anything above cost plus was automatically excessive. You see that squarely addressed and disavowed in paragraph 5.89, and it's also mentioned in paragraph 5.30. So we just say that that argument, which is also one raised in Flynn's respondent notice, is wrong, and wrong in principle. If I may just go back to the CMA's analysis, and I'd like to pick it up, if I may, in paragraph 5.274, which is page 1161 of the hard copy bundle.
Just pausing for one moment.
Yes, my lord.
Analysis or the description of the per se point in 5.89 is slightly different to the way in which it's expressed in 530, which is more generic, which is by reference to cost plus, not just plus, but it may amount to the same thing.
My suspicion would be that it does amount to the same thing, but my lord is entirely right, because one sees in the judgment reference made to 5.30 in paragraph 199, and the tribunal is saying, well, the CMA should have done more to clarify sort of over and above cost plus, where that is legitimate, what the tribunal calls don't produce a surplus. My response to that is, well, the decision does do that. Obviously, there's then a judgment that has to be brought to bear as to the extent of the excess, but we absolutely did not in any way say this was a cap or a collar.
I know we're perhaps jumping ahead to the cap legal point about per se. I mean, it uses the word per se, I think, in 530. Elsewhere, it uses the word a presumption. But it then, in a variety of different circumstances, for example, in relation to comparables, says that the CMA did not analyse comparables fairly because it took a per se approach. So this is something which appears to run through the CAT's analysis. Once it concluded that you were not accepting any justification above cost plus, I mean, that then fed into its argument about bias as well, that you effectively almost closed your mind to any other evidence.
And my robust answer to the tribunal's criticism is that is a flatly wrong and unfair reading of what the CMA in fact did. There's no presumptive for or against. There's an exercise of evaluative judgment. Cost plus is weighed in the balance. I'm just about to come on to show you the other points of reference that inform the CMA's analysis of excessive. This wasn't a simplistic cost plus test. There were other inputs that I want to show the court. And the trouble is just wrong to say that we approach this with a closed mindset or in any way determined to find a particular outcome. If I may just briefly show you 5.274, that's page 1236 of the electronic 1161 of the hard copy. And the reason to show you this is because this is where the CMA is discussing, just to situate ourselves, the WACC. And it's discussing the WACC and whether it's appropriate from Flynn's WACC for the particular supply of this focal product, the capsules.
Sorry, did you say 5.274?
Yes, my lord, that's exactly right. And what you'll see, I won't read them out, that the CMA makes a number of points, all of which are derived from findings made by either the tribunal or the experts, or was accepted by Flynn, basically that this is a business where there is little risk, guaranteed demand because of the clinical guidance on continuity of supply. There are no marketing costs, no bad debt risks because the NHS is the payer, no innovation. Actually, there are various indemnities that Pfizer gives to Flynn in case there is any manufacturing flaw. And, my lords, if I could just ask you all to read, please, over the page, the quote from the tribunal's first judgment in 2018. That's at 5.275. My suspicion, this absolutely nails it on the head. In fact, both tribunals agreed that the risks being run by Flynn are very limited and in any event covered by cost plus. But this is so important in my submission because what this does is it looks at whether a 10% WACC is appropriate in the specific circumstances of this line of business with these features, as you can see described. I'm conscious the court has already read, no doubt, the decision. So if I may just move then to my fifth step, and that is just to show you the CMA's analysis. To give you the references, this is set out in paragraphs 5.417 to 5.428 of the CMA's decision. And it drew on multiple strands of evidence. It's not a crude or formal analysis. And if I may just give you 5 highlights. Can we start, please, at table 5.17? That's to be found on page 1190 of the hard copy, which is 1265 of the electronic copy. And you'll see table 5.17 sets out the excesses. This is the CMA's base case. So this is a cost plus calculation where the plus is a 10% weighted average cost of capital. And you can see that what the CMA does is it shows the excesses at the bottom ranging from 37% right up to 139% above cost plus. Now, in line with what this court said in paragraph 199 of Liatharening, the CMA then goes on to look at the other evidence, all of which points in the same direction. And the next point to note is, secondly, it looks at the absolute returns as an obvious contextualising factor, which any business, including Flynn, of course, will consider its bottom line. And you can see that the absolute returns in the fourth row, excess per pack, that they range from £6.27 pure profit right up to £16.30. And it's worth just noting in passing, I don't turn it up, that this meant that capsules earned a much higher margin per pack than any of Flynn's other products. There was indeed a stark difference between Phenytoin and Flynn's other generic products. And that one can see in figure 5.2. And I'll just give you the reference so that you can see it. And that is on page 1169 of the hard copy and 1244 of the electronic copy. So absolute returns were the next input to the CMA's analysis. What the CMA then goes on to do responsibly is it cross-checked this analysis using the approach that Flynn was advocating, a return on sales approach. And one can see that if one looks ahead to page 1194 of the hard copy, 1269 of the electronic copy, that's table 5.19. And so what this does is this sets out what the excesses look like if you were to use the plus on a return on sales approach of 6%, which mathematically is an implied return on implied weighted average cost of capital of some 31%. We say it's a familiar story of demonstrably moderate excesses if you look at either the percentage or the absolute returns. The fourth point is one that I do want to draw to the court's attention, and it's that the CMA considered how Flynn itself approached the setting of prices during the relevant period. And to see that, can I ask the court please to look at paragraph 5.367 on page 1184 and page 1259 of the electronic bundle. This is under the heading Comparison of CMA's Cost Plus to Flynn's Contemporaneous Price Modelling. So this is a really good reality check as to what was going on the ground at the time. And if one reads, please, paragraph 5.367, you'll see that in October 2011, Flynn was modelling various prices. And if I could just ask you to underline the one for the most commonly prescribed strength, 100 milligrams, that was at £39.38 for a pack of 84 capsules. And then if we go down on page 1185, 1260 of the electronic copy, to paragraph 5.371, you can then compare that with the CMA's cost plus figures, which for the 100 milligram was £39.84. So they are almost identical. So before the price hikes that occurred that the CMA found and the tribunal found to be excessive and unfair, Flynn itself was modelling prices in the real world, as it likes to use as its catchphrase, and the CMA looked at its cost plus figures and they are anchored in the real world. There's barely any difference for the 100 milligram, the same is true for the 300 milligram, and so the CMA considers 5.372. This provides further evidential support for its cost plus calculation. And there's then a fifth strand to the excessive analysis.
Sorry, this takes into account the input price paid by Flynn to Pfizer.
The modelling world. Yeah. I would imagine that this modelling would have taken place before that price was set, because the price that Pfizer charged to Flynn is on the 24th of September 2012, so this is before that, but in a way...
This is October 2011.
Yes. But that's why it's actually...
They were in negotiation with Pfizer from... Well, it overlapped with the negotiations with Tor, didn't it?
That's right, Mark. Yes, it did. And really what we're saying is that Flynn was looking at the market. Flynn was making various modelling assumptions. Of course, my lord is absolutely right. One of the drivers will be the amount it pays for the capsules manufactured by Pfizer. But in a sense, what's so revealing about this is just in terms of put to one side the distorting effect of Pfizer's sky-high input supply price. Nonetheless, we see very close model projected prices and the CMA's cost plus figures. The two are very close to one another. The fifth point, the fifth strand to the CMA's analysis of excessive pricing is to be found in paragraph 5.424 on page 1196 and page 1271 of the electronic copy. And this was a comparison over time, so a comparator. And the comparison that was done was between the prices that Flynn charged from the 24th of September 2012 onwards with the prices that had been charged prior to that period by Pfizer when the product was still branded as Phenytoin. And you can see in 5.424 the various multiples in terms of how much higher the prices were. Now, of course, what Flynn say, in fact they assert in paragraph 6 of their principal written submissions, is that, well, the capsules before they were genericized were loss-making. Not quite right, because they were marginally profitable at times and loss-making at other times. But can I address this point head-on, please? Just ask the court to turn up footnote 1011, which is on page 1202 of the hard copy, page 1277 of the electronic copy.
Sorry, footnote 111.
So I apologise, my lord. It's footnote 1011 of the CMA's decision, page 1202 of the hard copy, page 1277 of the electronic copy. Because this is where the CMA addresses this point and actually sets out the sort of the factual position. And what in my submission is important to bear in mind is that what the CMA points out, so I'm just trying to pull it up, is that according to Pfizer, over a 5-year period between January 2007 to 2012, it incurred losses on its own measure of contribution of about 3.5 million. And then, in 2 months, September and October 2012, just 2 months, Pfizer earned profits of 4.4 million. So in other words, in 2 months, it recovered more than all the losses it's claimed to have incurred in the preceding 5 years. And you can see the analysis that the CMA makes of that in the text. The point really means is that any such losses, which were marginal at best, are not ones that in any way justify price hikes of this magnitude. The only other thing I would add, but just for your note, is that the Commission in Aspen, this is at Authorities 78, page 1557, just not to turn it up, but it's at recital 80, the Commission says even a loss-making price doesn't invalidate it as a comparator, you just need to take it into account, which of course is what the CMA did. Can I, before I move on to the Tribunal's judgment, can I just please invite the court to look at one other diagram? And this is to be found in the reference supplementary bundle at tab 13 at page 790, which is in volume 2, tab 13. And this is the CMA's skeleton argument for trial, and it's delightfully the same number between hard copy and electronic copy, page 790. And it just, you've heard me talk, we're hoping that a diagram sometimes is another way to visualise what's going on in this case. And what you can see here is, in my submission, a vivid comparison between Flynn's costs, that's the green, Flynn's costs, that's the green hatched bar for each of the strengths, and then Flynn's excess, that's the red hatched bar, which are of many orders of magnitude different from one another. The profits are substantial and persisted over a 4-year period. And so we say that when you look at that, and having looked at the various evidence put forward, the CMA was entitled to find that the prices were excessive. And with that, I propose to move to the Tribunal's judgment. Now start on a positive note, and that is that the Tribunal agreed with the CMA that cost plus was a valid test in this case. You'll note that's paragraph 57, which is at the core, volume 3, tab 32, at page 680, 755 of the electronic copy. That's paragraph 57.
Sorry, I'm just trying to catch up.
I
Sorry.
apologise, my lord.
I think we probably extracted the judgment and got it all scored over, but in the bundles...
I've done the same, my lord. So, but yes, in the bundles, the reference is Core, Volume 3, Tab 32, page 680 of the hard copy, 755 of the electronic copy. So there's nothing between the tribunal and the CMA as to the appropriate test. And a second piece of positive news is that the tribunal agreed with the CMA that the ROCI approach was sound and appropriate for assessing a reasonable rate of return for Flynn. Of course, CMA took a different approach in relation to Pfizer. And the tribunal makes that point a number of times. I'll just give you the references for now. At paragraph 90, paragraph 148 for Roman numeral 6, paragraph 183, subparagraph 1, and again paragraph 207, subparagraph 1. So we start on that positive note. I'd then like, if I may, to identify the errors of law that we say vitiate the tribunal's decision to set aside the CMA's decision. And there are 4 of them. I'm mindful of the court's steer that we should focus on our most important points. The first is, the tribunal, we say, was wrong in law to find that the input prices from Pfizer to Flynn were an illegitimate and irrelevant factor under the excessive limit. Secondly, with all due respect and deference to specialised tribunals...
Can you, I know it'll be on the transcript, can you just repeat that again, but just a fraction slower?
I apologise, my lord, yes. First, the tribunal was wrong in law to find that Pfizer's input supply price to Flynn was illegitimate and irrelevant to the application of the excessive limit.
And that was because of its conclusion that you needed to analyse this by reference to Section 18.
And Section 2, my lord. Yes, this is the idea that somehow in order to consider that matter, one necessarily has to find an infringement either of Chapter 1 or Chapter 2, and I'm going to seek to show you that's just not the case.
But that was the underlying reasoning which led to that conclusion, that the input price had to be viewed as normal competitive pricing.
This is yes, my lord. So this is paragraphs 132 to 136 of the judgment, to which I'll come in just a moment. I'm just going to identify the errors first.
Yes.
Secondly, the tribunal's concept of capital employed is novel, and with the greatest respect defies economic logic. It is striking that none of the parties, none of the experts, at any point equated capital employed in the supply of capsules with product unit cost. In my very respectful submission, no reasonable tribunal on the material before it could have reached that conclusion. Third, the tribunal misread and misunderstood the CMA's decision when it criticised the CMA's 10% WACC as no more than bare assertion, and that the CMA had focused on the wrong thing, the enterprise's WACC, rather than the focal product. You say that those criticisms are unfounded when reading the decision fairly and correctly as a whole, indeed, moreover, are irrational. The fourth point...
Just so we obviously got these from your skeleton, I just want to make sure I've got it as you articulated. Misread CMA with regard to the 10% as no more than fair assertion.
Fair assertion, yes. They say that the 10% WACC is conclusory. They're agreeing with Flynn that there's just no factual foundation and that it's no more than a bare assertion. So I'm going to seek to show you, as I have already done to some extent, there's a couple of bits more to sort of add to the evidential picture. And the tribunal also say that the CMA focused on the wrong thing, Flynn's WACC, as opposed to capsule's WACC. This is the enterprise versus focal product point. And we say again that misunderstands the decision. And it's just flatly wrong. Fourthly, the tribunal erred in law in devising a novel, we say, unnecessary requirement to consider the reasons for the extent of any excess above cost plus. This is the legitimacy of producer surplus point, which on the tribunal's own analysis is meant to be the function of the unfair limb. And we have a fifth point, which I'm just going to leave on the written submissions, which relates to the fact that Pfizer did not appeal against the finding of excessiveness, as indeed the tribunal itself recognised 3 times. I'll give you the reference, paragraphs 98, 209 and 284. As we say, in those circumstances where Pfizer did not appeal, because there is a chasm between its prices and cost plus, then in my submission there is no jurisdiction for the tribunal to set aside the decision. It hadn't been challenged, and therefore an unchallenged decision should not be disturbed by the tribunal. But I'm not going to focus on that this morning. If I may then turn to the first part of our first ground. That relates to ground 1.
Can I just check, because there are other points which you raise in your skeleton, for example, about the way the CAT treats comparators,
Yes,
foreign prices, its conclusion about changes in price over time. Are those matters which you're leaving to be dealt with in writing, or?
I'm going to address the court in relation to the comparators, yes, my lord.
Right.
Because that's an important point that Flynn relies upon specifically in its respondent's notice. Can we start to see how the tribunal's analysis goes awry by looking at paragraph 132, which in the judgment is page 743 of the hard copy, 818 of the 818 of the electronic copy. And what we see here under the heading Analysis and Conclusion is the tribunal say, according to Flynn's grounds of appeal, no improper collusion, Flynn just paid Pfizer's prices, and then over the page 133, the tribunal considers, halfway down 133, that the decision is underpinned by assertions that Flynn's costs in regard to capsules were not the true product unit costs, but just a ruse to disguise the massive profits that Pfizer and Flynn were jointly making. And it then says the decision approaches the profit margin as one calculated by reference to the decision between Pfizer's product unit cost and Flynn's product unit price. And then in 134, that is an illegitimate consideration. And it's illegitimate because, as my Lord Justice Green pointed out, early in the judgment, the tribunal, paragraph 130, appears to be of the view that you can't make a finding about the strategy of the parties to share profits without also finding either a breach of Chapter 1 or an abuse of collective dominance. And we say respectfully that that is wrong as a matter of law for 2 key reasons. First,
I'm focusing on 130 now.
Yes, I'm trying to read the... It's a bit disjointed.
No, I understand. I mean, as we understand it, 130 is the reason for the CAT's conclusion, and thereafter it applies that principle in a number of different ways, including in relation to the input prices from Pfizer to Flynn.
Indeed, my Lord.
So the logic behind the CAT's conclusion is that in 130. I think
I'm going to start and squarely address why that is wrong in law, and then I'm going to address why it's a material error of law.
Can I just ask then a couple of questions? So far as the exclusive distribution agreement between Pfizer and Flynn was concerned, did that contain any element of profit share? Because 130 could be construed 2 ways. It could construe the agreement as including profit share, or it could be the CAT's sort of overall loose descriptor of the arrangement between Pfizer and Flynn. But as we understand it, the distribution agreement didn't have any formal profit share element in it.
That's my understanding as well, my Lord. So essentially what happened was there were discussions, my Lord describes, between the parties, various presentations were made about prices, expected competition, profits, the fact that Flynn could be interposed effectively for reputational reasons, and you then have Pfizer set the supply price, and then Flynn just decides what markup it puts on top of that. And so there was no part of the CMA's case that there was any sort of joint profit sharing to that extent.
So the CAT is really using this expression as a loose label for the arrangement. And so then the question would be, given that presumably most commercial agreements, in a loose sense, seek to generate profits for both parties, can you have a profit share arrangement in that sense without it being unlawful?
Yes, well, I think it's a bit more than just the arrangement. It's also the party's strategy, essentially,
Well, exactly.
why they're doing what they're doing.
That's why we need to work out whether they're applying it in a formal sense as a description of the agreement, which I don't think is the case.
No, that's my
Or
understanding.
whether they're using it in some loose term, which really reflects the findings in the decision about the commercial negotiations and its underlying purpose, which you say was to share profits in a loose contextual sense. And then as we read 130, they say you can't have a conclusion that there was sharing of profits in that loose sense without there being either a cartel or joint abuse.
Yes, my lord. It might be helpful to look at what the tribunal first time round in 2018 found on this point, because that then informs and is relied on by the CMA in response to this. My understanding, particularly given the quote in 129 from the decision, is that they are not saying that the agreement itself contained what are alleged to be unlawful profit-sharing provisions. It is a looser idea that the parties came to a sort of joint strategy of genericise Phenytoin, and then both of them put up the prices and then share the spoils. And
I mean, the point I'm making is it's a narrow one. If this is the point at which one finds the cat's reasoning, which it then applies to the facts elsewhere, then as we understand it, that they're equated, they say you can't have a profit share arrangement without it being unlawful. That seems to be the underlying logic.
Yes.
And if that's the case, that would render a lot of agreements, which are generally viewed as commercially normal,
particularly
unlawful.
vertical agreements, my lord, where there is.
But cooperation agreements, joint ventures, which may have formal profit shares in them.
And that wasn't a point that was really canvassed by the tribunal at the trial. It's not the way that the CMA had sought to rely on these arrangements. The CMA was seeking to rely on them. Perhaps best actually just to show you.
I'm sorry. Just put the first line. We do not see how the statement that there was a sharing of profits can properly be made without a finding.
So we say that is wrong as a matter of law. As you are putting to me, of course there can be sharing of profits. It depends on what the terms are and what the market context is. But at no point was it being said that any time undertaking share profits with one another, that in itself is the breach. Rather, what we said was, you look at what the parties were seeking to achieve, as my lord put it, the purpose of the arrangements, and that is a legitimate factor that can be taken into account in a Chapter 2 analysis. And that's the bit I want to focus on.
But I mean, we were trying to identify precisely what it was in the judgment, or if you like, what the cat's starting point for this point was. And it struck us it was probably the first sentence of 130. So,
yes, my lord, I would agree with that they basically think you cannot rely on the purpose of the arrangements between the parties unless you say that the arrangement itself is unlawful, either because it's an abuse or because it's an anti-competitive arrangement. My response to that is you can rely on the purpose of the arrangements because they shed light on what the parties were seeking to achieve. I was going to show you both what the CAT found first time round and also an authority, a European authority, that squarely addresses the legitimacy as a matter of competition law that you can take into account the business strategy of the dominant entity.
I think we had it in Swindon.
You did, my lord. You had it in Swindon, paragraph 123, but you also have it from the Court of Justice in Tomra. If I may just simply show you that authority, then what the tribunal found, and then I'd like to show you what the CMA actually did. So the authority is, yes, authority in paragraph 123, but can I show you the Court of Justice in Tomra? So it's pre-Brexit authority. In the authorities bundle, tab 69, page 1294.
Sorry, tab
69, my lord. And the relevant page is 1294 of the hard copy and 1319 of the electronic copy. And the relevant paragraphs for this purpose are paragraphs 18 and 19 of the court's judgment. So we say that where you're looking, it's actually not even an option. This is something that the responsible competition authority must consider in terms of the business strategy. And it's clearly a legitimate factor for it to plug in this case. My Lord Justice Green says this court affirmed the same point in Lyotharington. Can I show the court, however, what the tribunal itself found, which is what actually kind of gives rise to this point, in its original judgment, first time round. It's paragraph 457, which is to be found in the core bundle, volume 2, tab 30, and it's page 556 of the hard copy, and 631 of the electronic copy. Just for the transcript, I think it's important just to sort of set out the findings. It's finally and critically, the evidence consistently showed, the evidence before the original tribunal, that the strategy jointly evolved between Pfizer and Flynn to remove phenytoin sodium capsules from the pharmaceutical price regulation scheme and to price them at a much higher level, close to the then drug tariff price of tablets, I don't know if Mr. Holmes will address you on, was based on a clear-sighted view by both of the increased profit that would flow to each from that arrangement. Indeed, that was the admitted purpose. And you can see that they had discussed the percentage split of that benefit, but ultimately reached a commercial solution that was based on the supply price, providing each with a satisfactory share of the increased profit. Over the page, they did so irrespective of the fact that Flynn was left free as a matter of contract law to determine precisely what price it actually set. Pricing was an integral part of the strategy, radically to improve the profitability of the capsules. So we say that if the tribunal had been right in paragraph 130, then it would have been wrong earlier in the proceedings to have made that finding relating to the strategy jointly evolved by the parties. Indeed, the CMA rely on that finding in paragraph 6.26 of the decision. But there is a further point to make about this, which is that if we go on to the way in which the tribunal then applied this point, and this is now going back to 133 and 134 subparagraph 1, what appears to be driving the tribunal's concern...
I'm still catching up with
I
paragraph.
apologise, my lord.
Right.
I will try and go a bit slower.
Right, no, don't worry. Paragraph.
It's 133, my lord.
Yep.
And then, in fact, it's a little repetitive. It comes back again in 134. But it's the point about this essentially being that the decision approached the profit margin as the difference between Pfizer's product unit cost and Flynn's product unit price. But perhaps I don't even need to turn it up. As the court will recall, when we looked at the CMA's decision, the CMA did not do that. One of the very few things upon which the CMA and Flynn actually agree is that the CMA was right to use the actual cost that Flynn incurred in paying for the supply of capsules. Those were the figures set out in table 5.9 of the CMA's decision. It didn't disregard an inconvenient truth. And you can see from its principal written submissions in this case, at paragraph 85, the parties are ad idem on this point. What the CMA did do, in my submission it was right to do, is that it proceeded looking at the actual costs, but then it stepped back and asked itself, what implications do those actual costs paid to Pfizer have for the level of Flynn's percentage profit margins? And there's a really good illustration of that point in the CMA's decision, where one can see exactly why the CMA was concerned to make sure this point was properly considered. If I could ask the court, please, to pick up the CMA decision again, to look at a different passage. It's in the core bundle at page 1180. So this is tab 33, volume 4, page 1180 and 1255 of the electronic copy. And the relevant paragraph is paragraph 5.348, and the table there, table 5.15. is a striking illustration of the risks that one runs by simply ignoring the impact of Pfizer's supply price on Flynn's percentage margins. So this is where the CMA is doing a comparison over time. This time, it's comparing the prices that Flynn paid to Pfizer during the infringing period with the prices after. So we saw earlier it was a comparison before. Now we're seeing a comparison after, where of course the prices have been brought down. And what we can see, if we look in the two columns, is that, starting with the bottom, the return on sales for Flynn actually are virtually the same. It's 28% during the infringement. Actually, it's higher during the 2 years after the infringing conduct. Even though, of course, as you can see, the radical difference in Flynn's total costs, the input costs, have come down from £37 to £4.70. But my submission is that you then look as a cross-check at the absolute returns, and they are vastly different. And you can see there, they were £15.23 relevant period for the 100 milligram capsule, the most popular strength, and that is multiple times higher than the figure set out for 2018-2019. And this shows you the risks of distorted analysis if you look at simple, unadjusted return on sales comparisons. And it's for that very reason the CMA didn't apply return on sales as its primary approach, and moreover, it sought to take this point into account in the weight that it would give. And while we're here, could I actually ask the court, please, to look at paragraph 5.399, because we have another vivid illustration of the same point. Expressed slightly differently, I think it's also quite powerful. So page 1191, paragraph 5.399, page 1266 of the electronic copy. And what we see here is, again, that if you take the prices that Flynn currently pays Pfizer, which are after the infringements, and you run the excesses on a percentage margin basis, the excesses go through the roof. Just on the 100 milligram capsule, we go from 37% to a whopping 724%, simply because of the impact that Pfizer's prices have in suppressing the percentage excess. So we didn't disregard this, but we absolutely did take it into account and were alive to that distortion. And so we say that on this point, the tribunal was wrong in law to characterise the CMA's reliance on the purpose of the arrangements and the parties' strategy as if it implied a breach of Chapter 1 or Chapter 2. And we say it's also wrong in law that as a consequence the tribunal fails to take itself account of a relevant consideration, highly relevant, which is the way in which Pfizer's supply price affects and suppresses Flynn's percentage margins. Now, my learned friends for Flynn say in response to this, well, this is all academic, because we agree that the CMA used actual costs of goods. But my response to that is it's far from academic, it's fundamental. We know it's fundamental because, as my Lord Justice Green has put to me, that you start from the wrong starting point, as if this implies unlawful collusion or an abuse. You then move to ignore the points I've just shown the court about how the input supply price distorts and suppresses Flynn's percentage margins, making it look far less excessive than in fact it is. But there is more to it than that, because, as my Lord Justice Green put to me, the tribunal then gets the wrong end of the stick when it starts to evaluate Flynn's evidence, because you see this as like a fault line that runs through the judgment. Because if we move on to paragraph 176, just very briefly, just to show you this, you'll see this point pop up again and again. So this is at page 788 of the hard copy, paragraph 176, 813 of the 863 of the electronic copy. And you can see here, this is just to situate ourselves, dealing with one of Flynn's comparators. And what is being said is that the CMA were wrong to have rejected the CMA's comparator by reason of Pfizer's high input price. It was a materially irrelevant consideration. In fact, we say the true position is the opposite. It's a materially relevant consideration. Otherwise, you end up making the mistake of looking at unduly low percentage margins, which are in fact being inflated by Pfizer's supply price. And of course, as my lords know, the tribunal comes back to this point at paragraph 281 of its judgment in the context of confirmation bias, where it says the CMA has been over-influenced by these arrangements. And we say that's because it has erroneously misdirected itself as to the relevance and the legitimacy of these arrangements. And my learned friend Ms MacLeod will address how the CMA was scrupulous in maintaining an open and fair mind in that respect.
Can we just track back from 176, footnote 271?
Yes.
Is said to be the basis, the reasons given. That goes back to 134, which is the conclusion to the text from 130 to 134.
Exactly. So if one, my lord is quite right, if I may say so, to do that. To trace it back, you can see that these are all interconnected, and that the finding there in 176 is traced back to 134. My lord will just screen put it, that itself starts off from a fundamentally incorrect premise in 130.
Well, it does take us back to the question I asked at the beginning, which is, how does one analyse 130? Is it right to equate an agreement, which is a sharing of profits, with something which in law must necessarily be unlawful?
We don't understand it to ever be in dispute that such an agreement is not in and of itself unlawful. The tribunal cites no authority for that. And the CMA's position is that that would not in itself necessarily be unlawful. You'd have to do an analysis of the particular arrangements and the strength of the parties and the context. You can't make an arid, abstract statement of the kind that's made in 130. It's not how competition law works. It has to be put into its context. And that isn't done in this case.
I mean, it does go on to say in 113, no doubt the higher prices resulting from the arrangement between Pfizer and Flynn are relevant.
But then, in a way, when one reads the judgment as a whole, one finds these tensions and inconsistencies. And so that's what I propose to say in relation to that part of round one, the first part. Move on to the second part, if I may, that an irrational approach was adopted to capital employed. And I'm going to focus on two key errors of law, which, again, just to identify them at the outset. First, the tribunal took into account an irrelevant consideration in conflating Flynn's operating costs, product unit costs, with its capital assets. That was a category mistake. Operating costs are part of the cost in cost plus, whereas capital employed is firmly part of the plus. They're not the same, and it's perverse with the greatest respect to treat them as such. And the second error is that the tribunal erred in effect, allowing Flynn to recover product unit costs twice over. Once as part of the cost stack, and then again as part of the return on capital employed. It's what we've referred to as double counting.
That flows from the first error.
It does. They are interrelated, my lord. You're quite right in that sense. So we say that what this does is it invalidates the tribunal's finding in paragraphs 156 and 207 subparagraph 2 that the decision of the CMA had understated Flynn's capital employed at 3.5 million when it should have been 74 million. We just say that really is so out there that no reasonable decision making could have reached it.
156 and
207 subparagraph 2, my lord. And what I'd like to do, if I may, is just walk us through the judgment and how these concepts are clarified, and then how they become, in my submission, somewhat baffling and very difficult to comprehend. We start out, if we may, in the judgment with the concepts of product unit cost, and that is clarified in paragraph 58, and that is on page 680 of the hard copy and 755 of the electronic copy. And I'm delighted to say that in paragraph 58, the CMA has no objection with that definition of product unit cost. It's in parentheses. You'll see that it refers to the cost of producing and selling the focal product, here capsules only, underlined. And indeed, the CMA itself adopted a similar definition in paragraph 5.6 of its own decision. And so what we see here is the cost of producing capsules as a sort of flow quantity. It is costs incurred on a recurring basis and again recovered on a recurring basis. So we have no problem with that definition. What we then have is the tribunal in paragraph 60 seeks to unpack various factors of production, well known in economic textbooks. And I'd like to focus, if I may, in paragraph 60, subparagraph 1, Roman numeral 3, which is at page 682 of the hard copy, 757 of the electronic copy. And what we see here is the tribunal unpack two meanings of capital. So you start with the idea that various people may use tools, machine factories in the process of making other goods. And you see the tribunal say that capital has two different meanings. One from the Dictionary of Business, apparently, which is the one referring to plant, machinery and equipment. And then it goes on to say, but it can also refer to the funds invested in a business in order to acquire the assets which the business needs to trade. For the purpose of United Brands, the second definition, or a variant of it, is to be preferred. Now, just pausing there for a second, that second definition, the funds invested in a business in order to acquire the assets which the business needs to trade, we agree with that. That's consistent with what the CMA was looking at. Again, for your note, you'll find our definition, an orthodox one, in paragraph 5.34.1 of the CMA's decision, which in fact is quoted by the tribunal itself later on in paragraph 86 of the judgment. So far, so good. Capital employed and product unit costs are different. And we don't understand this to be in any way controversial in dispute between the CMA and Flynn. None of the experts suggested that they were in the same thing. Where things go a bit pear-shaped is on page 683, where, continuing the discussion, the tribunal then gives what it calls its primary definition of capital. It doesn't say capital employed, but capital. And you see it's the money required to acquire the inputs needed to make the focal product.
I'm afraid I'm going to complicate matters. I'm not looking at either the bundle or the trial. I'm looking at the judgment.
You've got a paragraph. Okay, no problem at all. Paragraph 60, subparagraph 1, Roman numeral 3. It's a rather long subparagraph, and there's a little quote in italics.
Yeah.
Page 45 of the judgment.
Yeah.
And it's that where, in my respectful submission, we're not entirely sure where this comes from. The footnote doesn't help. It might come from how an economist might think about capital in a microeconomics textbook as a factor of production. But what we say is that this is a contortion of the orthodox and long-established meaning of capital employed for the purposes of a rocky approach.
Yep.
And Flynn say, oh, you're quibbling about terminology. It's not a quibble, it's a fundamental point. There is a key distinction, just so that we're all clear. Product unit cost measures the undertaking's cost of production for every unit produced. Capital employed is the assets, tangible and intangible, used by the undertaking for the supply of a product. In my respectful submission, it's irrational to conflate the two, because what you're effectively doing is you're conflating the cost element with the plus element. And that results in a very muddled and, we say, irrational outcome. Now, to see this through, we now need to look at the assessment the tribunal does of the CMA's decision on capital employed. And for that, can we go, please, to paragraph 153 of the judgment, which is to be found for, well, this is screen, page 134 of the internal judgment, and for Justice Snowden and Zacaroli, that is 772 of the hard copy, 847 of the electronic version. So this is the tribunal's analysis of the CMA's decision in relation to capital employed. We start in 153 with a familiar friend. That's the definition that I've just submitted. It makes no sense at all. It's a perverse meaning of capital for the purposes of a rocky analysis. What goes on in this paragraph is something, if I may say so, that is very strange, because it goes on to quote something from the decision of the CMA, but unless it's me, I have not managed to find this italicised sentence anywhere in the decision. It is not, I would submit, a verbatim quote, as is suggested by the italicised indentation. It's a very loose paraphrasing, I think, of paragraphs 5.232 and 5.233 of the decision. But actually, that's not even my main concern about this. My main concern is that this is not the CMA's definition of capital employed. The tribunal continually refers to capital, but we're talking about capital employed for a rocky approach, which the tribunal itself says is the appropriate, correct approach. And we don't need to turn it up, but I'll just simply tell the court that statement appears under the heading working capital, which of course is a subset of capital employed. It is not the definition, the specific definition in the CMA's decision of capital employed. So we just say that that's completely misread and misunderstood what the CMA was doing. That only relates to working capital. But then the ultimate problem is at the end of 153, where we are told that apparently the working capital, this is the last three lines, is not a reasonable rate of return on the product unit cost of the focal product. The decision comprehensively asked the wrong question, and the answer is unsurprisingly incorrect. Well, with the greatest respect, we say this turns matters on its head. Working capital, everyone agreed, Pfizer, Flynn, the CMA, and all the experts, there was a consensus that working capital is part of capital employed, and therefore, to which an undertaking is entitled to a rate of return. The bizarre, in my submission, is for the tribunal to suggest the rate of return is on the product unit costs, just conflating costs on the one hand and plus on the other. And no one ever suggested that. But the problems, I'm afraid to say, only get worse as one goes on. Because if we then look at paragraph 154 of the tribunal judgment, we see that this is dealing with a specific part of Flynn's working capital, the buffer stock that it built up to deal with any supply outages. And we're told in the first sentence that it has nothing to do with the product unit cost. Pausing there, that's correct. It doesn't. It's capital employed, which is why you have a return on it as part of ROCE. What we are then told is that the decision takes this working capital figure from Mr. Walters, the director of Flynn, and his evidence, which is directed to a relevant cost that has nothing to do with product unit costs at all. So we're repeating the same point. But so far, we agree that these are different things. And there's then a quote from Mr. Walters' statement. But if we turn over the page, this is where we're really going off the deep end, because in paragraph 155, we're told this has nothing to do with the question posed by the excessive lien. Well, the court has seen the authorities I took you to at the beginning of this morning. This is absolutely everything to do with the plus in calculating cost plus in applying the excessive lien. Working capital, again, Flynn and the CMA agreed that this was relevant and should be taken into account as part of capital employed. So we just say this is an astonishing statement that does reach the high hurdle of being irrational. Now, of course, with all due respect and deference to the tribunal, one needs to try and understand how it reached such a startling conclusion. And one sees that sort of explained in the sub-paragraphs to 155. We can see that the tribunal explains that there is a difference to its mind between a dynamic approach and a static approach to costs. And as far as that goes, the CMA doesn't have any problem with that. Of course, a dynamic approach is one that looks at the cash flows of a business over time. Pausing there, that's exactly why the CMA calculates working capital, so that one can see on a real-time basis over time whether you're more in debt or more in credit and so that you've got the cash on hand to effectively finance your everyday operating expenses. So that is what working capital is for.
It's in the retaken decision, the CAD addressed the question of dynamic and static and held that it didn't matter, and there was no criticism of the CMA for adopting a non-dynamic approach. Wasn't that in the is that in the retaken?
Yeah. Which paragraph does my lord have in mind?
I was hoping you'd tell me that.
It may well be, my lord, in terms of the...
There's an analysis of the annex focal point date in which it... Well, maybe it doesn't matter, but I mean, I recollect that they actually said the difference in dynamic and static was not something they were criticising.
It's page 254 of the judgment, paragraph 306.2. This is where the CAT is deciding for itself the reasonable rate of return. And you're quite right, my lord, there is this point made about, well, actually, this is generous on an industrial scale to Flynn to use, wrongly, we say, the product unit costs. But this is what the tribunal did, and therefore it doesn't matter whether one looks at it on a non-static dynamic basis. Or is that the point you had in mind, my lord?
Well, there's that, and there's a point in which they expressly say they don't criticise the CMA for not using the dynamic approach.
I'm delighted if that is the tribunal's position. That my only point about the dynamic static is to try and understand why on earth, respectfully, the tribunal is making this point. Because why would you conflate operating cost and capital expenditure in this way? Because it seems as though one sees in little paragraph 3 that the tribunal is of the view that you need to have the cost of capital be related to the Annex 3 data, as the court probably knows, are the focal product spreadsheets that have the month-by-month volumes, costs and prices. That's what the Annex 3 data is referring to.
Yes.
And so it appears that the tribunal is concerned that we haven't taken a sufficiently, we haven't adapted our approach to reflect this point about how things change over time, which I have two answers. One is we did do that. Working capital is indeed a dynamic approach. And the second is we were right in a very orthodox way to distinguish operating cost and capital employed. And this is a really material error. We see that in paragraph 156 of the judgment. Because even though cost of production and capital employed are completely different, what we actually see in 156 is the tribunal say that the annual figure of 3.5 million of capital employed is a gross understatement of the capital needed by Flynn, where in essence what the tribunal does is it takes the 4-year figure of 74 million, so that's total product unit cost. Just for your reference, you get that from paragraph 105, subparagraph 6. So what it's doing is it's taking out the CMA's orthodox figure of 3.5 million for each year of capital employed and substituting a whopping 74.1 million figure, which is pure operating costs, and says that that is the capital that should have been taken into account. And we just say that that is wholly unsustainable. It's not rationally supportable to have reached such a conclusion. If I may rely on the time, I'm going to move on to the related errors my Lord Justice Zacaroli identified. And that is the point about double counting. Because in essence what one finds is that as a consequence of conflating product unit cost and capital employed, what one then finds is that you have Flynn and Pfizer being entitled to recover the operating cost as part of the cost within cost plus. And you recover that on a recurring basis in the ordinary course of business. You incur your operating costs, pound for pound, you then recover them. But then on the tribunal's approach, you then take all those costs and for a second time, you put that into the plus element and you say, well, that's capital employed, to which now, for the first time ever in competition law, you're allowed a return on those operating costs. Not one authority in any excessive price case has ever suggested such a thing. and then you're allowed to have a return and recovery of those costs, even though you've actually already recovered them. And I would like to show the court, because I've been focused on Flynn this morning, but it might be helpful, I hope, to just show you Pfizer, because Pfizer is the one that actually has tangible assets, and it's considered in the judgment. And it actually, in my submission, is a good illustration of where things just go horribly wrong. So if we go please to paragraph 100 in the judgment, that's page 712 of the hard copy, page 74 of the judgment internal numbering, page 787 of the electronic version. As the court will recall, because there are difficulties in allocating capital to the particular capital strengths, the approach the CMA adopted to Pfizer was different. So for Pfizer, because of those difficulties of allocating capital employed, the CMA's primary method was a 10% return on sales, increased from 6% the first time round. And then here we see the rocky cross-check that was done on that reasonable rate of return. And we start by noting in subparagraph 1 that the CMA estimated that the capital employed by Pfizer in the production and supply of capsules was 3.5 million for all the capsule dosages. And it is right, as noted in footnote 112, Annex K may not be necessarily at the forefront of your minds, but it is worth a read, if I may say so, because it sets out clearly the approach that the CMA took to calculating the capital employed. For present purposes, that's the manufacturing factory in Freiburg, the various buildings, plant and machinery that Pfizer UK had, and its working capital. There is no reference by either the CMA or Pfizer to the cost of raw materials, product unit costs, being in any way relevant or to be taken into account as part of capital employed. But what we then go on to see in subparagraph 3 over the page is the tribunal goes through the CMA's calculation of capital employed, and it says, we say rather strangely, that the manner in which this figure came to be calculated is not apparent from the decision. Well, we're somewhat baffled by that, because if one looks at table K9 on page 1510 of the core bundle, you can see very clearly where that figure comes from. But in any event, the bit I'd like to focus on, because it's relevant to this point, is over the page again, if I may. And this is where, so I'm now, just for the court's note, paragraph 100, subparagraph 3, subparagraph Roman numeral 5. And again, the tribunal repeats it not being clear about where the figure of 3.5 million comes from. Again, Annex K. There's then a very odd reference to the reading needing to be the one most favourable to Flynn. I think that must be a typo and should be favourable to Pfizer. But the key point is what's then said under the table. There is thus a mismatch between the top-down capital employed figure used by the CMA for calculating the capital employed and the total product unit cost involved in the production of the same capsules, between 3.5 million on one hand and 12.5 million on the other. And this mismatch needs to be explained. Now, the answer, of course, is that Pfizer is quite properly entitled to a rate of return on its capital employed, that is the 3.5 million, and the plus in the cost plus calculation. But it is not, makes no sense whatsoever to say that it could also return on the 12.5 million of operating costs, product unit costs, because it's already covered those. And so you end up with this double counting, which we say makes no sense whatsoever. What perhaps is happening here is that maybe the tribunal had in mind a cost markup approach, which is actually just a different approach to profitability, quite apart from the rocky method that it endorsed and that the CMA applied, and that Pfizer didn't appeal, and that Flynn's expert, although it had criticisms of Rocky, nonetheless, at no point ever suggested that Rocky is to be applied by reference to product unit cost. And we say that this is just not reasonably open to a tribunal to calculate capital employed for a Rocky framework in this way. with that, I'm going to move on to the reasonable return. So my third error of law, we say, again, is an irrational rejection of the CMA's approach to calculating the weighted average cost of capital. And it makes sense to start in the judgment. If I may, we're going to look at the tribunal's assessment of the CMA's decision on the WACC. And that is to be found starting at paragraph 164. Which is, I apologise, page 778 of the hard copy, 853 of the electronic copy, and of the internal numbering, it is page 140 of the judgment. And again, we have a heading analysis, so this is where the tribunal is setting out its review of the CMA's decision. And on a positive note, it starts by saying that the specific criticisms set out in the notice of appeal of the CMA's weighted average cost of capital are not particularly well made. In fact, the CMA quite properly considered various points advanced by Flynn, suggesting a higher WACC, and rejected them. So far, so good. However, the tribunal goes on to say in 164 and 165 that it agrees with Flynn's point that the CMA's WACC, in quotes, lacks a solid factual foundation. That's said to be a fair criticism. There's then a partial quote of the decision. And that the tribunal then in 165 says doesn't understand the real basis for the reasonable rate of return, no more than a bare assertion that the WACC is 9%. That was actually the statement of objections. It was 10% in the decision. And that this is a conclusory finding. And for that reason alone, they would allow the appeal on this ground. Well, if I may, just to sort of respond to that, we just say that is a profound misreading of the decision. Because if we look at simply the quote alone, and that's not all of the CMA's analysis, you can see there that the CMA relied for factual foundation on Pfizer's WACC, 9%, and from Flynn's own expert, where there was an average cost of capital for, that should be pharmaceutical, that's a typo, not pharmacological, pharmaceutical companies, between 7.7% and 8.2%. So those are two real-world inputs to the selection of the WACC. But as I mentioned to the court earlier, the Pfizer WACC actually this perhaps is worth looking at because it's so important for the evidential pedigree of the CMA's analysis. Can I ask the court, please, to maintain the judgment open and to pull up a little bit of the CMA's decision. So this is in Core Bundle, Volume 4, tab 33, and I would like to go to page 1139 of the hard copy, which is 1214.
Can I just clarify what the ground of appeal point is here? You are essentially taking issue with the CAT's analysis of the decision as being conclusionary and lacking factual basis.
Yes.
So your exercise is to demonstrate what process.
Not what process,
CMA,
my lord.
Well, what evidence that CMA
Indeed. We want to say that it was irrational for the tribunal to have reached this conclusion because had any reasonable tribunal read the decision, it was plain as a pikestaff that we had evidence supporting it. Of course, you could disagree with it, but what you can't do, we say, is to characterise it as bare assertion, conclusory findings, or lacking solid factual foundation. So yes, my first target here is just to show you that there were factual foundations for the WACC. And I've done that to some extent already, but I'd like to just show you a couple more points, which I hope will be useful as points of reference.
At some point, perhaps you could just very briefly pull it all together in a series of propositions about the categories of evidence that you say were taken into account.
Yes. I can do that right now, my lord. So the first is the one I mentioned, Pfizer's WACC at 9%. Second, I was just going to come on to this, but I'll just mention it. Pfizer's manufacturing facility in Freiburg made the capsules, had a WACC of 8.5%. That's to be found in paragraph 5.170 of the decision, what we were just about to look at, and footnote 811. And that's really important because it's linking the company WACC to the specific focal product. Third, that we had, as you could see, the figures from KPMG of the average cost of capital of various pharmaceutical companies. Fourth,
Hang on a sec. No.
I apologise.
Do you want to just give us? I mean, this is a useful overview. So if
Yes.
you give us the paragraph numbers.
So for that,
So
it's
c-
paragraph
yeah,
5.
yeah.
Yes, I apologise. So for Pfizer, it's paragraph 5.170. For KPMG, it's paragraph 5.171 and also 5.260. We then, thirdly, rely upon the valuation that was carried out by an investment bank, Jefferies, of the Flynn business using a 10% WACC, which is set out in the decision at paragraphs 5.267 through to 5.271. So that's an analysis that was done in 2012. So in other words, right at the beginning of the relevant period, projecting future cash flows using 10% WACC. And then last but by no means least, the CMA also fourthly took into account various publicly available information on the WACC of other pharmaceutical companies, ranging from 8.7% to 9.3%, and that's to be found in paragraph 5.271. So we say there are multiple points of evidence, all of which are pointing towards a 10% WACC. There is a fifth that was introduced for the purposes of the appeal. The CMA's economic expert did a bottom-up calculation of the weighted average cost of capital specifically for capsules, and the crispest statement of that is in Mr. Harmon's position paper, which is in the reference supplementary bundle at tab 20. Sorry, the core supplementary bundle at tab 23 at page 218. And the relevant paragraph is paragraph 4.16. And I'm going to come on to that in a moment if I may, so that's relevant to the other criticism that CAP makes. But it means that you have multiple strands of evidence, all of which are underpinning the weighted average cost of capital that was being used, all of which are real-world reference points. The idea, we say, that the tribunal says that this is just pure assertion is manifestly incorrect. Maybe with that, I don't necessarily need to go through each of those sources. And it has been said by Flynn that we just relied on a single slide deck of an investment bank, Jefferies. But I hope the court can see that that is just manifestly not the case. There were a number of different points that fed into the CMA's analysis. In fact, the tribunal doesn't even mention the Jefferies valuation. So again, it just seems that it's either misread or misunderstood the CMA's decision in relation to that point. So we say that that means the first criticism is wholly unfounded and unwarranted. We then have, if we go back to the judgment please, paragraph 166, what is said to be a more fundamental problem. So the tribunal is criticising the CMA for having apparently looked not to the focal product, capsules, and the product unit cost, and we've already covered that that's not right, but to the enterprise. But again, with the greatest respect, this is another misreading of the decision. And the court will recall, I showed you this, and I can turn it up if you need to look at it again, that the CMA specifically, in paragraph 5.274, looked at the activities that Flynn engaged in, limited though they were, and the risks that it incurred, limited though they were, for the supply of capsules. That was the sort of 6 propositions of inelastic demand, low risk, and the various contractual indemnities that Flynn had. And we say that that paragraph is doing exactly what the tribunal says we didn't do. That is to say, we went from the enterprise and then we looked down to the particular product and asked ourselves, was there anything about that product, risks, costs, investments, that means that it needs a higher WACC than 10%? And we say that the answer to that is obviously no. But the tribunal doesn't even mention or grapple with any of this. But the other thing that I've already mentioned, but it's relevant to this point as well, is that the judgment doesn't mention evidence of Mr. Harman, the CMA's economic expert, that specifically looked at the WACC for the focal product. And it might be useful very briefly just to take a glance at that. It's neatly summarised in the core supplementary bundle. So can we turn that up, please? And it's at tab 23, at page 218. And this was squarely in front of the tribunal because the CMA relied on this evidence in its written closings in paragraph 42 of Annex 2. So it was not a point that should or really could have escaped its attention, but it doesn't get any consideration in the judgment. And the relevant paragraph is paragraph 4.16. So this is page 218 of the core supplementary bundle. Under the heading, the 10% WACC is suitable for capsules. And you'll see Dr. DeConnick, that's Flynn's economic expert, is criticising the CMA's 10% WACC as being unreasonable. And Mr. Harman disagrees, but he then summarises helpfully the WACC analysis he did specifically for capsules. And indeed, he himself then cross-checked that with evidence in the decision, CMA's findings in liothyronine, and the various WACCs that are used for impairment testing purposes and valuing assets for tax purposes. And you can then see that he concludes the WACC is likely to be between 6.4% and 10% for capsules, and therefore the CMA's use of Flynn's WACC of 10% is reasonable and it's all of a piece with one another. And he then goes on to make the point that the CMA makes in paragraph 5.274, the cost of capital for capsules is unlikely to be higher than for Flynn as a whole, because it's likely to have a lower relative exposure to market risk than Flynn, in part due to inelastic demand. So we say that the criticism that we focus on the wrong thing, looking at the enterprise, and we should have looked at the focal product, well, we did. And it's the tribunal that here has palpably failed to actually read and follow what the CMA and its independent expert had done. If we can go back, please, to the judgment, paragraph 166. What we then are told in 166 is that the decision doesn't ask 2 key questions. And I know it will sound a little bit pantomimesque, but they say that, but we absolutely did ask those questions and answer them. And I'll just simply give you the references. First of all, what is the reasonable rate of return to the entrepreneur for selling capsules? Answer, paragraph 5.277 of the decision, the WACC of 10%, for all the reasons set out and the evidence set out in paragraphs 5.259 to 5.276. I don't turn it up, but that is the answer. Secondly, does the WACC constitute a good proxy or means of assessing the reasonable rate of return? Answer, emphatically yes, for 4 strong and compelling reasons. Number 1, the 10% WACC reflects a real-world, market-based, average percentage return on capital used by Flynn. Number 2, the 10% WACC reflects the limited commercial risks and limited activities that Flynn incurred in supplying the focal product of the capsules. Number 3, the 10% WACC was in line with Pfizer's own manufacturing plant for capsules. That's paragraph 5.217. I apologise. That's paragraph 5.117. And lastly, yes, of course, it's a good proxy because the CMA's expert did a bottom-up calculation, which we've just seen. And so we say that in relation to this, the tribunal is obviously wrong to find that the CMA didn't ask itself the very questions that the CAT identified to be relevant. We asked them, we answered them. In my submission, the tribunal's judgment is just emphatically wrong in its conclusion in paragraph 168 that we failed properly to address the reasonable rate of return. It's actually the tribunal itself that's failed properly to read the decision. Now, before I move on, it's important that I address, at least I haven't yet heard what the Flynn appellants will be saying about this, but in their written submissions, one of their sort of carrying calls is to say, well, this WACC approach is only focused on cost of capital and you've neglected return on capital. And so they say you've just got to get out in the real world, look at some normal returns for products like phenytoin. And we say in response to that, firstly, the CMA approached the WACC in accordance with the authorities that we've seen, the Patterell and liothyronine. There's been no error of principle in adopting a WACC. And just for the court's note, I don't think I need to turn it up, but not only the tribunal has done that in liothyronine and in Le Patterell and in Kent Apple, but also the OECD. I'll just give you the reference supplementary bundle, tab 103, page 1999, also understands and applies ROCE and the WACC as an appropriate benchmark for the ROCE. But there is a point in the judgment, which actually my Lord Justice Zacaroli had asked earlier, that is worth drawing to the court's attention because it's relevant to this point that Flynn is seeking to draw, this distinction between cost of capital and return on capital. Could I ask, please, the court to go back to an early part of the judgment, which is under the heading CMA Cost Plus in paragraph 80. It's subparagraph 3, subparagraph Roman numeral 2, which is page 61 of the judgment, 699 of the hard copy, 774 of the electronic copy. And this point came up from the former president of the tribunal.
Sorry, can you just give me the electronic number again?
Yes, my lord. It is 774, my lord. And the relevant subparagraph begins, the decision calculates the reasonable rate of return by reference to ROCE. Does my lord have that? I'm grateful. And so the former president of the tribunal asked leading counsel for the CMA a question. Essentially, what is this? Is it a cost or is it a return? And there is, in my submission, I gratefully adopt my learned leader's answer. You'll see in footnote 90. The cost of capital is both a cost and a return, depending on whose perspective you look at it from. For the business, it's a cost, which they have to pay to investors, for them to invest their capital. So for them, it's a cost. But equally, for the investors, the lenders of their debt, or the shareholders that provide equity, it's a return. It's the return that they get on their capital. And so we say that's, in my submission, entirely right. It just depends, they're two sides of the same coin. And it just depends if you're looking at it from the business perspective or from the investor's perspective. But I can also pray and aid the tribunal's own understanding, although it waxes and wanes throughout the judgment. But there is a helpful statement, which we haven't yet looked at, on this point. If we can go, please, to paragraph 63, a little earlier in the judgment.
I'm being a little bit dim. What is this point actually going to?
This point, yes, no, not at all, my lord. It's just that Flynn are saying, oh, CMA, you're obsessed with a WACC. That's just cost of capital. But what you should be looking at for the plus is the return. And my answer to that is the cost of capital is the reasonable rate of return. The CAT says that in liothyronine and again in the Patterell. It is also stated by the Commission in Aspen. And I was just trying to understand why actually there is no difference. And actually one would be giving undue headroom to Flynn if they were allowed to have a return over and above. Do you remember in the Aspen decision, my lord, the Commission said, in principle, no further remuneration is to be, and what Flynn is seeking to do is have something
But it simply flows to your point that a WACC is both a cost and a return.
Exactly right. It's both, they're one and the same thing.
Yes.
I'll just very briefly show you the point from the tribunal, just because we hadn't looked at it, and it's under the heading reasonable rate of return. So this is paragraph 63, page 47 of the judgment, 685 of the hard copy, 760 of the electronic copy. And so what we see here is the tribunal sort of set out some of its thinking about what is meant by reasonable rate of return in paragraph 63. And it's the second sentence onwards that is of interest. It may be that it's defined by reference to what an economist would call normal profit. That is then explained to be the level of profit equal to the opportunity cost of entrepreneurship. Pausing there, we agree. That is exactly what the cost of capital is looking at. It's where the investor has £1 million, they're going to invest it in the business, but they have to ask themselves, well, what else could I do with that £1 million? If I could get a lot more money doing something else, then I need a return on that. That's the opportunity cost, and we say that's exactly right. That's what the cost of capital is seeking to achieve, seeking to look at. And if we read on, we see that the tribunal explains normal profit is the fair reward for the effort the entrepreneur puts into running an enterprise and the risk they take on. We agree. And normal profit exists, and this is quite important, at the equilibrium where the entrepreneur stays in business, doesn't leave the market, no new entry caused by the level of profit. That's exactly what we saw in paragraph 566 of the tribunal's judgment in La Passerelle. So whether Flynn says you're just saying a minimum or a floor return, it's not a minimum or a floor return, it's normal profit. Anything above normal profit is pure economic profit, which is part of the excess. As we say that at least that bit of the tribunal's judgment makes economic sense, we respectfully say, and we agree with it. I'm going to move on, if I may, to the third part of our ground, one, unless the court has any questions relating to the concepts of capital employed or the WACC. So we do say that the CMA's cost plus figure is a valid and sufficient way of establishing that the prices are excessive, especially whereas in the decision it was cross-checked in multiple ways. And I'll come back to answer some of Flynn's points, seeing how they develop it tomorrow. So the third part of our first ground is that the tribunal go on to say that one needs to consider the reasons for the extent of the excess. And we can see that if we move forward in the judgment to paragraph 204, which is on page 175 of the judgment, page 813 of the hard copy, and 888 of the electronic copy. So the point that we object to is in the third sentence. They say, having said that the producer's surplus, that's just the tribunal's terminology for the indication of the amount of margin above the reasonable rate of return. They say, we don't consider it inexorably follow from the existence of producer's surplus that the excessive limit is satisfied, without at least some inquiry into the basis for the existence of that producer's surplus. And so what it's doing is saying, well, we need to go away and ask ourselves, well, why is there this chasm between price on the one hand and cost plus on the other? And I'd like to make 4 brief submissions about why that is wrong as a matter of law.
So just making sure we understand precisely what the objection is. It is that the CMA, the CAT, thought there was an error on your part because you failed to identify the reason for the excess.
Correct. Under the excessive limit. That's going to be relevant. That's going to be relevant to the submissions I'm going to make.
But it's a fairly narrow.
It is quite a narrow point. And they're not.
Are you required in law to explain the reason? And if you are, have you done so?
Yes, my lord. And I'm going to focus very much on the first point because we say that there is no such requirement.
But
it's a narrow point, but it's important, obviously, for the CMA's future.
If the assumption behind this statement is that there's always, in every case, a surplus which is legitimate, then there may be reason to explain where that is. If, as you say, you can in principle have a case which set at cost plus, and indeed the tribunal it also says that in the judgment, then that answers the question.
It does. And we say one doesn't make assumptions about the legitimacy or otherwise on exercising an evaluative judgment to sort of compare.
What do they mean by reasons? I mean, if the reasons are that, set aside the facts of this case, the reasons are you analyse the evidence, you conclude it doesn't add up to anything, that's the reason. You're just pushed back to CP, cost plus.
Indeed, my lord.
So
I imagine, well, it's not entirely clear what the tribunal has in mind, but what it appears to be doing is to say, I observe the gap, the excess, and is that gap attributable, for example, because, as indeed is found later in part 2 of the judgment, that there's distinctive value from continuity of supply. At least for so that might be a reason why some of that producer surplus is legitimate. That's sort of the line of inquiry the tribunal appears to have in mind.
Yes.
And my point is, well, that is no part of the excessive limit. Neither you nor the Chancellor at the time in Phenytoin I said that that's part of the exercise. It's never been part of the authorities that you look at the reasons for it. And that is because the unfair limb is, you've got to think about what are their tasks. Excessive is about determining whether the prices and the margins are excessive. And we all accept that's just stage 1, limb 1, the first part of the analysis. And then there's the question of, well, what do you do under the unfair limb? And there are obviously two
alternatives. I understand that, but
there.
I'm just looking at the actual reasoning. Because if you're right on the facts, then it doesn't arise as an issue at all. Because you will have set the threshold for fairness at cost plus, in which case, by definition, there's no surplus, producer surplus, using their terminology, which needs to be explained.
Yes, although I'm not presuming that I'm going to win.
No, I'm just wondering what, if there is a producer surplus, then you would need to evaluate it.
Under the unfair limb, that's my point. As a matter of law, it's the unfair limb is where you evaluate it. And what the tribunal is doing is almost it's saying, have a quick look, do an abridged analysis of the existence of producer surplus, which ironically, when the tribunal itself comes to do this later on in its judgment, in paragraph 314, the tribunal says, well, we don't need to do this under the excessive limb. So actually, if you read the judgment as a whole, there's an inconsistency. They criticise us for not looking at the reasons for the producer surplus, and then they themselves say, on the facts of this case, we don't think it's necessary or appropriate to consider the legitimacy of Flynn's producer surplus under the excessive limb. That's paragraph 314. And the reason why I do understand, my lord, one needs to ask, well, is this really a material point? And the reason why we say it's material is because there's a risk, if this judgment stands, that the parties will then complicate and make it far more complex than it needs to be, the excessive limb of the analysis.
Yeah.
And we say that actually you should have
I understand
clarity
that.
as to...
I mean, there's another issue which arises in relation to that, which was the approach which the CAT took in Le Petorel, which was actually to say they needed to simplify all this, and you apply a somewhat mechanical approach to both cost and plus. And then everything else is just justification, which deals with both excessiveness and fairness. And that on one view, is a simpler approach to take.
I have it in my notes to say that the CAT in Le Petorel puts it rather well in paragraph 53 of the judgment, which is for the benefit of the court. What the CAT says is that perhaps what we should do is a linear process under the excessive limb, where you identify a relevant benchmark, you then work out if there's an excess of the price over that benchmark, and then the third part is that you then ask, is that excess significant and persistent? And then you leave all of the...
Everything goes to justification.
Exactly, it goes under the question, is it fair or unfair? I mean, we have some sympathy for that, but obviously it's only a...
It's not the way it was applied here. Well, we said it was sensible, I think.
You did indeed, my lord.
But I mean, the word excessive is not part of the statutory test. It comes from United Brands.
That's right, my lord.
And it can have meaning both as a noun and as an adjective. As a noun, it's the excess of the selling price over cost or cost plus. That's just the excess of A over B.
Yes.
You have to work that out in any case.
Yes.
It's also excessive as an adjective implies some degree of criticism. It's beyond that which is normal. And so if you look at whether something's excessive and then also ask if it is whether it's unfair, you've got two exercises, both largely addressing the same thing. And there's only a single statutory test, which is fairness, not excessiveness.
Yes. Although the court has always approached it
No.
since United Brands as having these sort of two stages.
Yeah.
And I think then to sort of rationalise it, it makes sense to say, well, stage one is to work out, as my lord puts it, is there a significant persistent excess?
Yeah.
And then stage two is then to say, well, hold on, is that unfair for particular reasons, or is there something that explains and justifies it? I think the way you put it, my lord, justification really is a
Well, you don't lose anything by putting it in the way the cat did in the Petrel, because absolutely everything goes into the mix.
Exactly.
So everything which would go into excessiveness, value, benefit, whether the consumer values it, it's prepared to pay a premium, comparables, it all goes to justification. And on that case, the cat found that quite a high margin was reasonable.
Yes.
By looking at it more holistically, rather than breaking it up into chunks. I mean, there's something to be said for simplifying it in that way.
Well, I'm all in favour of simplifying, facilitating enforcement. I think the difficulty with this point is that if you have to start to take a quick look at the reasons, then you're starting to preempt the analysis that should probably be done under the Appellant. So we're just wanting the coherence of how the test is to be applied.
Okay.
Lord, I indicated at the outset that we do also say that Pfizer hasn't appealed and that the tribunal therefore had no power to set aside the decision in relation to the excessive pricing. We don't understand Pfizer to suggest the contrary on that issue, and so we just rest with paragraph 59 of our principal written submissions. What I would like to do, if I may, in the remaining time, is briefly address one of the core points. This is the last part of my submissions, dealing with what Flynn say, purportedly by way of respondent's notice, in terms of its comparators. And for present purposes, having not yet heard Flynn on this, I'll simply make two overarching points, if I may. The first of those is that the tribunal was right to say that return on sales is not the appropriate approach. All Flynn's comparators go to the question of return on sales, or gross margins. That's the first point, which is a key point of methodology. And then secondly, that it's abundantly clear that the CMA, in line with Lord Justice Green's judgment in Phenytoin I, discharged its duty of fairly evaluating each of the comparators. So, just to show the tribunal why the tribunal itself didn't assess these comparators, it makes sense if you've got the judgment to pick it up in paragraph 173 and subparagraph 5, please. Core Bundle, Volume 3, tab 32, page 148 of the judgment, 786 of the hard copy, and 861 of the electronic copy. Just to orientate ourselves, I should just say this is in the part of the judgment dealing with the comparators advanced by Flynn. And I will go through each of those briefly. They're identified in paragraph 172. But for present purposes, I just want to make a more overarching point and a fundamental one. We'll see that in subparagraph 5, it said that Flynn relies upon this data, that data being the various figures, the ROSs for its various products in its portfolio, none of which have anything to do with phenytoin other than their products owned by Flynn. And what we see halfway down, the CMA did not accept that the Rose approach was appropriate, a stance we agree with. And the decision explains why, even if the return on sales was the correct methodology, these comparators did not assist. So here the tribunal is making very clear that the correct methodology is the ROCKY framework that the CMA applied, and the incorrect and inappropriate methodology is return on sales. I'm not going to, actually I would like to show the court, if I may, because the tribunal agrees with the stance the CMA adopted, just can I briefly show you one paragraph, which is a nice crisp statement of the reasons why the CMA thought that ROS was inappropriate and not to be applied. I apologise, we have to go back to the CMA decision one more time. That's in the core bundle, volume 4, tab 33, at page 1165 of the hard copy, 1240 of the electronic copy. And the relevant paragraph is paragraph 5.289. under the heading CMA's consideration of Flynn's comparative representations. And in essence, the CMA makes 3 points which clearly have the tribunal's stamp of approval. We see paragraph 5.289.1. Flynn's standalone ROS analysis is not informative of how returns compare to the investments required by Flynn to supply capsules and the risks assumed in doing so. A standalone ROS analysis provides little insight into the underlying economic profitability of capsules. So you see immediately that just looking at a return on sales figure, profits as a percentage of revenue, that is not going to tell you anything about the actual risks and activities carried out by Flynn. But there's more than that over the page, because what we're told, secondly, is that doing a simple return on sales analysis fails to take account of Flynn's arrangements with Pfizer, the point we covered earlier this morning, about how if you look at the high supply price, it has a distorting effect on the ROS percentage margins, thereby hiding the true scale of profitability. We say that's a highly relevant consideration. Now, I do accept the tribunal will disagree with us about that point, but as my laws will have it, my submission is that they were wrong in law to have said that. The third point, which actually is 5.289.4.
Sorry, to what
I apologise, my lord.
5.2892.
Yes, my lord.
Can you just unpick the sentence? Whose profitability are they talking about there?
Yes, quite right, my lord. Flynn's profitability. So this was the point we covered this morning, where...
Is this just doing it in percentage terms?
Yes, yes.
This is the 28%, 30%.
Exactly, exactly. And so we say that that is another reason why this is not an appropriate methodology. Although, as a responsible agency, we did a cross-check using this methodology anyway, but we do have conceptual reservations about it, with which the tribunal agrees. And then the last point, 5.289.4...
I'm sorry, and just...
I apologise, my lord.
So I don't want to get hung up on this particular thing, but why is its position in the supply chain hiding the true scale of its profitability?
I think what is meant, my lord, is explained in footnote 910. The idea is that you've got Pfizer up here. It is the manufacturer in the supply chain, my lord, and then just down in the supply chain, interposed, Flynn is a distributor.
It's not so much where it is in the supply chain; it's that it's paying a high cost.
Yes, my lord.
Via the product.
Yes, my lord. Footnote 910 arguably does a better job of explaining the CMA's concern.
Yeah, okay. That's fine. Thank you. Sorry.
I'm grateful. The third point to note here is that phenytoin capsules were highly unusual in terms of their high volumes, high input costs, and low commercial risk, making it extremely difficult to identify a sufficiently close comparator. And indeed, this is a point that the tribunal itself had said is a problem. If we go in the decision to paragraph 5.310, that's page 216 of the internal numbering, 1171 of the hard copy, and 1246 of the electronic copy. And this is just to show you a point that came up first time round, where it was not in dispute that any comparators, this is for a ROS analysis, have to be objective, appropriate and verifiable. Mr. Harman was correct in the tribunal's view to identify highly unusual features of Flynn's phenytoin business. We see again the high price it's paying to Pfizer. And then this. This may have made it difficult to draw reliable comparisons to the remainder of Flynn's portfolio. Phenytoin clearly occupied a very unusual position in Flynn's portfolio, given its absolute level of profitability, its size, and its input costs. And then you see that the tribunal reaches the conclusion that they preferred the view of Mr. Harman, the CMA's expert, to Flynn's expert. And so we say that when you consider that point, the point that it's going to be very difficult to get a sufficiently close and meaningful comparator for a ROS analysis, that's why the tribunal agreed with the CMA that ROS is not appropriate, and there's no need for the tribunal or this court to delve into the detail of Flynn's ROS comparators.
But I mean, is what they're saying there? They're not saying that the particular drug is any different from any other drug. It's just saying they're just saying what the the thing that distinguishes the capsules from any of the other things that Flynn buys and sells is the arrangement that it has with Pfizer.
Yes, my lord, but it's a point that perhaps I'll just give you the reference for it rather. Each of the factors referred to by the tribunal, costs, risk, the activities, are factors that can affect the level of profit and the level of ROS. And because of that, when you're going to compare ROS for phenytoin, you need something sufficiently similar in profile for investment, cost, risk, volumes. And what the tribunal is saying there, to get a like-for-like comparison is going to be very, very difficult. And what I'm probably going to have to address to you for a little while after lunch is just on each of the comparators, they're nowhere close to phenytoin for this to be in any way informative or relevant to what is a normal return for that product.
But is that because the product itself is different, or is it because the arrangements that have been
Oh, I
made?
apologise, my lord. It's because the product itself is different. The arrangements obviously are relevant in that regard because they drive up the supply price.
Well, save in relation to tablets, where the conclusion was that because of continuity of supply and the MHRA guidance, suppliers held dominance, and that was the reason, I think, in relation to tablets.
Yes.
For AEDs, it was somewhat different.
So my lord has already anticipated my response on tablet margins, which my learned friend Mr. Holmes will be addressing you, not tablet margins, but the tablets market. The reason why those margins are not reliable or informative is because the CMA found the tablets market was not workably competitive, and the CAT agreed with the CMA, actually, as my lord of the screen says, finding that each manufacturer of tablets was a dominant position in its own right, and therefore it's not a valid comparator. And we agree with that.
In the retaken decision, they dismissed tablets on that basis, and I don't think they refer to AEDs at all, anywhere.
No, I think that's right, my lord. It doesn't. I mean, other AEDs is not really at the forefront of Flynn's comparators in any event, but unfortunately that has addressed one of them. Just in case it's relevant for my Lord or Justice Snowden, the paragraphs I had in mind that are relevant to this point about comparability in the decision are paragraphs 5.44 through to 5.48 of the decision, which is at pages 1110 to 1111 of the hard copy. I have an eye on the time,
Yes.
and I'm thrilled that I'm almost at the end. I haven't quite completed, however. I just need to have about, say, 10 minutes after lunch to address you very briefly on each of the comparators and how they were fairly evaluated. And then the baton will pass to my learned friend, Mr. Holmes, King Counsel, to do address you on fairly.
Thank you very much.
Very, very
2 o'clock?
All rise to table.